Hi everyone, I am Suyash and today I will talk about the case of Pradeep S. Vodiyar versus the state of Karnataka, wherein the Honorable Supreme Court discussed the concept of cognizance as enshrined under the Code of Criminal Procedure. But before adverting any further, let us understand the dictionary meaning of cognizance. Black's Law Dictionary, 8th edition, defines cognizance as a court's right and power to try and to determine cases, or the taking of judicial or authoritative notice, or acknowledgement or admission of an alleged fact. On the present show, we will be more concerned with the definition that explains cognizance as a court's right and power to try and to determine cases. Basically, Section 190 of CRPC states that a magistrate may take cognizance of any offense when A. The magistrate receives a complaint of facts which constitutes an offense. B. There is a police report of such facts. And C. Information is received from any person other than a police officer or upon his own knowledge that an offense has been committed. Thus, aforestated are the three modes by which cognizance may be taken under Section 190 by a magistrate. It sets out the different ways in which a magistrate can take cognizance of an offense, that is to say, take notice of an allegation disclosing commission of a crime with a view to setting the law in motion to bring the offender to book. But what about the Court of Sessions? How can a Court of Sessions take cognizance? Till now, we have talked only about cognizance by magistrate. According to Section 193 of CRPC, no court of session shall take cognizance of any offense as a court of original jurisdiction unless the case has been committed to it by a magistrate. Thus, usually, a court of session shall take cognizance of any offense when such case has been committed to it by a magistrate. In case there is any express provision to the contrary, either in the CRPC or any other law, the same shall override the mandate of Section 193. In this regard, Section 209 may also be apposite for perusal. It states that when a case is instituted, either on a police report or otherwise, and it appears to the magistrate that the offense is exclusively triable by the Sessions Court, he shall commit the case to the Court of Session. Further, it is also to be noted that the expression used in these provisions is cognizance of any offense. Thus, cognizance is always of the offense and not the offender. According to the court, the word cognizance indicates the point when a magistrate or a judge first takes judicial notice of an offense. It is entirely a different thing from initiation of proceedings. Rather, it is the condition precedent to the initiation of proceedings by the magistrate or the judge. Cognizance is taken of cases and not of persons. In the present case, the court also explained that the purpose of taking cognizance of the offense instead of the accused is because the crime is committed against the society at large. Therefore, the grievance of the state is against the commission of the offense and not the offender. In view of the court, the offender as an actor is targeted in the criminal procedure to provide punishments so as to prevent or reduce the crime through different methods such as reformation, retribution, and deterrence. Cognizance is thus taken against the offense and not the accused, since the legislative intent is to prevent crime. The accused is a means to reach the end of preventing and addressing the commission of crime. Therefore, in conclusion, following points emerge. A. Cognizance is a court's right and power to try and to determine cases. B. Section 190 provides for the modes of taking cognizance by a magistrate. C. Section 193 provides that a court of session shall take cognizance of any offense when such case has been committed to it by a magistrate. D. Section 209 provides that when a case is triable exclusively by court of session, the magistrate shall commit the same to the court of session. E. Cognizance is always of the offense and not the offender, since the legislative intent is to prevent crime. And F. The accused is a means to reach the end of preventing and addressing the commission of crime. Thus, I hope that the nature, meaning, and the scope of cognizance under CRPC is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.